The law is a writing profession.
To our listeners, if you think you're going to come into a law school and you're like, you know what, this exam's going to be multiple choice, say goodbye to multiple choice. I can't tell you I actually can. The last time I had a multiple choice exam was in college. It's not going to be in law school.
So I like to emphasize to my students, day one, when I meet them in August, that words are the essential tools of our trade.
Welcome to the Bar None podcast. It's the podcast that cuts through the casebook and classroom chatter to bring you real talk about law school and the legal world and beyond. I'm your co-host, Ted Delsima, and I'm joined as always by
Adon Ordonez.
And each and every week, we sit down with amazing professors, partners, lawyers, and law insiders to really break down what actually matters. No fluff, no filters, no BS. Whether you're a 1L, a rising associate, or just law curious, this is the space where you're going to find honesty meets the law. And today's episode, we are excited because we're joined with Professor Torres. She has extensive experience in legal writing, and her background in trial and appellate work and just her employment at Miami Law obviously resonates a little bit with me as being a graduate from there. But Adon, I know you had her as your LCOM professor. I'm going to give you the honor of introducing her.
Yeah, Professor Torres was, I would say, my favorite professor while I was at Miami Law. I took her my second semester for LCOM, what we call LCOMs, or legal writing class, or second semester. And so she taught me everything that I know, like quite literally everything that I know about persuasive legal writing. And, you know, it's just a blast to have her. I know that Professor Torres, before she was a professor at Law, she practiced, you know, so she practiced what she preached in class, I'm sure. So I'm very excited to have her today. So Professor Torres, how are you doing today, first of all?
I'm doing well. Thank you both for this opportunity and for that very warm welcome. It was always such a pleasure to have Adon in class and such a delight to have this opportunity now to catch up and witness what you're doing in this new chapter of your life.
I think the first question we start with is, what drew you from a successful career in litigation to now teaching legal writing at the University of Miami?
Yeah, that's a great question. I thoroughly enjoyed my career. I was a partner at Stearns Weaver. I had the benefit of working with fantastic colleagues and clients. And I thoroughly enjoyed the practice, specializing in employment defense for approximately 17 years. But I had always thought about this notion of a profession having three acts, so to speak, beginning by learning, then practicing, and finally teaching, giving back to the profession by nurturing and mentoring the next generation. So by the time I had been practicing for about 16 years, I started thinking about what that next chapter would look like for me. I knew that it wasn't about going to another law firm or going in-house. I really wanted to focus more so on service and perhaps education. And around that time, Dean Patricia White was beginning her tenure at Miami Law. And of course, the ABA and law schools generally around that time were heavily focused on experiential learning and amplifying those offerings, making them much more robust. So to that end, you know, as both of you might know, having been students at Miami Law, she started to really create more clinics. She developed the LCOM program, hired a director. So I was delighted when I was given the opportunity to join the inaugural LCOM faculty. And I just completed my 15th year teaching LCOM. So clearly it's a decision that I've been happy with.
Well, congratulations. Wow, wow, wow. And for some of our viewers, again, so our viewers are going to range from 1Ls, associates, and just people that are thinking of going to law school. What is LCOM? Is it a course that's taught by all law schools? Is it unique to What is LCOM, Professor Torres?
So we lovingly refer to the class as LCOM. That is shorthand for legal communication and research skills. So while the LCOM brand, so to speak, is unique to UM, legal research and writing is, of course, not unique to Miami Law. It is taught by just about every law school. It just takes a different format in each school. Miami Law, of course, had legal research and writing classes before LCOM, but they were taught primarily, not exclusively, but primarily by adjuncts. And so that had some pitfalls because, of course, the student experience was not uniform. And by not having full-time faculty, they were not fully engaged. They were not really present on campus. Students had difficulty reaching them outside of class and so on. So Dean White really wanted to raise and elevate the way in which we were teaching legal research and writing. And she also wanted to expand the focus to include not just office memos and trial briefs, but really all forms of communications, including client communication, right? So much of what we do as lawyers consists of emailing clients, writing letters to clients, even texting clients. And so by hiring full-time faculty members to teach LCOM, Dean White really wanted to elevate the experience, make it much more consistent across the entire 1L class, and make us more of a presence within the law school faculty. And of course, she also charged us with developing upper level writing classes. So we've done that as well. And I've co-developed and co-taught upper level writing electives that focus on summary judgment motions, as well as client communications. Because of course, having practiced for so long, a very common frustration for lawyers is that we hire junior associates who don't know the first thing about communicating with clients.
That is big. And this is coming from a former partner at Stearns Weaver. That is big. And me as a practicing associate attorney or whatever you want to deem, I remember my first year right out of law school, Professor Torres, where my boss was like, hey, yeah, just communicate that to the client. Let them know we agree and we're going to move on this motion. And that took me 2 hours to draft what could have been a sentence. It's, when I tell you, you overthink these things and you're so nervous, you're like, it's the client, you got a piece of responsibility. So it's very big and it's very important, Professor Torres, that you said, not only is it a focal point for but this class is going to teach you not only basic understanding, legal writing and research, but just communicating with clients. And I have clients that text me. When you said that, like it triggered a story. I'm like, oh man, let me tell you about John. He likes to text, and sometimes you forget that you're an attorney because a client might text you at like 9 p.m. on a Friday and you're out with your friends, maybe dinner or something, and you're like, wait a minute, I can't use acronyms. I can't say LOL or, like there needs to be a level of professionalism. So that's definitely refreshing to hear you say that. And my
That's
next
such a great point, Ted, because sometimes the speed and the lack of formality with texting
Mhm.
is a trap for the unwary.
Yeah. Oh, wow. Yeah. Yeah. Listen, and that's important. So to our all our listeners, 1Ls and students considering it's important. It really is. You're not texting your friends. You're not emailing your friends. You got to be mindful and you got to put your best foot forward because they're going to remember that. And now I'm at a point, right? And this is just a subset, Professor Torres. When you get to a point where you've built a relationship, like with some of these clients, we've done team building trips together. I have pictures of their families. The conversation may become more casual, but you always want to start on a professional note, whether that's emailing or texting. So I definitely agree with that. But my question is LCOM legal writing and research, is that a course best served for first year, first semester at law school?
I believe it is because one thing I have realized over the years is that shockingly, many students arrive at law school without a really solid appreciation for the importance of legal writing. The law is a writing profession, by which I mean most lawyers over the course of a long and successful career will write more words, fill more pages than journalists and novelists, for example. But yet, a lot of our students don't come to law school, don't arrive on campus with an appreciation for that. So they underestimate the extent to which they really need to cultivate their communication skills, both written and oral communication. So I like to emphasize to my students, day one, when I meet them in August, that words are the essential tools of our trade. And that the legal profession, functioning as an attorney, it is a huge privilege. But yes, it's a privilege that comes with a tremendous sense of profound responsibility. Because when you really think about what we do as attorneys, we get paid to think. That's it. Our clients hire us because they have legal problems that they cannot solve independently. So whether it's a transaction or a civil or criminal matter, they need us to think about their problem and develop a strategy to achieve their goals. But our thoughts, no matter how brilliant we might think they are, become virtually meaningless to our clients if we cannot skillfully and effectively communicate to the client, to opposing counsel, to colleagues, to judges, whoever else may be involved in that matter. So communication is essential. It's at the heart of everything we do. And so I think, yes, we should absolutely begin 1L year with a focus on that, and then continue to cultivate those skills at the upper level.
Yeah, it's a foundational course. And I couldn't agree more because and Adon, I want you to speak on this because I'm thinking about my first semester in law school. And my background's a little different, Professor Torres, in that the law was my second career. I was in finance, for 6 years. I'm a non-traditional law student. I came in there in my late 20s and I had spoken to clients. I had spoken to business partners, decision makers. I had built a book of business, but still, I was so excited to take my legal writing and research course because it's different and it's not the same. And it goes to the point you said, what's the point of having all the smart if you can't articulate it, if you can't synthesize it to a degree that your client who's not doing what you do understands and agrees with you? So I mean that's big for me. And one thing I always say, Professor Torres, and you could agree or disagree, the law happens in your inbox. I tell students that all the time. The law happens in your inbox. I'm not in court every day. You see what I'm wearing? I'm wearing my moot court, little sweater. I'm home. I work from home. And sometimes if I have a hearing, I'll fly in for that or I'll go to court. But half the time, opposing counsel, they're emailing me or I'm emailing the clients or the clients are calling me or I'm on Zoom. So it's very important. And I'm going to switch gears. Adon, how did you feel? Like you also have a very cool background in that, you were a professional athlete. You had, the family business. You had your own career prior to law school. How did you feel when you're like, oh my God, I got to take this LCOM thing? I already know how to speak. I already know how to communicate. What was that feeling for you?
Yeah, it's actually crazy hearing Professor Torres say what she said. As I remember during class, she literally told us that she was like, words are tools, like, and we get paid to think. And I had her the second semester, so I had this idea of how the law was supposed to be, and that almost flipped a switch for me. And I'm like, wow, like I'm really gonna get paid to think. I'm really, I'm rewarded by thinking. And that honestly, that's one of the things that really draws me to the law and that I didn't know the first semester. And so, coming from again, similar to you from a different background, I thought that, texting or whatever I wrote was good enough. But when you get to law school, you realize that you learn how to communicate effectively. And that's kind of what we're doing as lawyers is we're solving problems through our words, but we're communicating effectively with the client, with the judges, and it all starts with legal writing. And one of the reasons why Professor Torres was the first person that I reached out to when I knew we were going to do this podcast. because I think the writing, like the LCOM class, it sets the bar for every other class that you take in law school, because it is writing. And law school, I mean, every exam that you take, even if it's a multiple choice exam, you're reading and you're not writing in a multiple choice exam, but you're thinking as if you were gonna write. You're solving problems with your brain, like Professor Torres said. And if it's not a multiple choice exam, which most of them aren't, it's a issue spotter exam,
Nope.
and it's writing. And I think for me, my second semester, I made the flip also of, okay, I'm gonna write these exams in a way that makes sense to me. To okay, I'm gonna write these exams like how I learned it in LCOM, and it made a big difference. I performed better because of it, and it's a very legal writing is very specific, but I think the way that, at least the way that I learned it at University of Miami, it's starting to get way clearer. Sometimes you read these Supreme Court opinions or the old cases, and you don't understand what they say. And I think the way that lawyers are beginning to write now, and the way that we learned it in school, it kind of comes together to where you're writing for clarity, and you're writing for, to solve problems. It's like you're not writing for somebody else or to seem smart. It's like you're writing very practically. And I mean, I just really enjoyed that about LCOM and about, just the legal writing altogether.
Yeah, and it makes me think it's more, Adon, what you're saying, it's a progression because to our listeners, if you think you're going to come into a law school and you're like, you know what, this exam's going to be multiple choice, I could pass this, say goodbye to multiple choice. I can't tell you I actually can. The last time I had a multiple choice exam was in college. It's not going to be in law school. So it is the focal point. It is important that this course, and the reason why we wanted to start this podcast with LCOM, legal research and writing. All universities have a variation thereof that they teach their first year, first semester, is because it's going to set you up. It is the chassis for you to get better throughout the other courses because all your exams are going to be writing. They're going to be issue spotters, writing. There's no more multiple choice till you get to the bar, whether it's Florida, New York, whatever bar you want to take. I got to ask Professor Torres, like in your 15 years, you're celebrating 15 years. What were some common concerns you saw with your students when they first started law school or first started their LCOM class with you? Because I'm sure people are utilizing you for office hours and you're on campus. So what are you seeing? What are some fears and concerns?
Yeah, I think first and foremost in the fall, students come in with a fear of the unknown. And so I view my job as most often the first professor that they see in a classroom because they generally take their LCOM class before any of the other classes. I view my job as trying to demystify the process, explaining to them that they will continue to rely on the same great study habits and skills that brought them to law school, but they're simply going to level that up and adapt that to legal education, learning the language of the law. And I urge them to treat the law as exactly that, a new language. Every time you come across a new word, look it up if you don't understand it. Because the quicker they become fluent with the language of the law, the quicker the concepts and theories that they are learning across the entire 1L curriculum will make sense to them. And they'll start to connect the dots between the various things they're learning. And I do encourage them to meet with all of their professors during office hours, because of course, you may think that you're getting everything you need during class, but quite often students have questions and concerns that they're not comfortable raising in class. I also explain to my students that unlike some of the doctrinal classes where they might be in a class with 50, 60, even 70 or 80 other students, we have very small class sizes. Communicate freely and openly in class. I make sure that they understand that there are no dumb questions. It always breaks my heart a little bit when students raise their hand and say, this is a dumb question, but there are no dumb questions in LCOM. And I try to encourage my students to speak up and participate. Any question or concern that one student has, chances are all students in class have. So I try to make it a very accessible class, and I try to make myself available as much as possible to students outside of class time to talk about anything, whether it's LCOM, law school generally, the legal profession, searching for jobs. I'm happy to talk to my students about all of it. And then in the second semester, and I had a Don for LCOM 2, we pivot from predictive writing to persuasive writing. Mm-hmm. And I always hear the same thing, Professor Torres, I am terrified of public speaking. You're going to make me speak in front of the class. You're going to make me deliver an oral argument. And I have no idea what any of that means. So again, my job is to demystify the practice, make my students understand that it's like anything else. You simply have to practice and prepare. And the more practice that you get, the more comfortable and confident you're going to be. And so we never grade our students on the first assignment. We always begin with ungraded assignments. We give our students ample opportunity to practice and get feedback and repeat. And so ultimately, we are not grading our students until they've had an opportunity to do something several times. At its core, I think my job is simply to make my students as comfortable as possible, be as accessible and available as possible, so that I set them up to succeed, not fail.
Yeah, and I see students, and there's this, I don't even think it's a rumor anymore, because there's this air where it's just like you're either going to be litigation or transactional. If you're going to be litigation, you should focus more on public speaking and really sharpen your writing. Whereas transactional, I'm just doing, maybe discovery, or I'm doing something along those lines. Those skills shouldn't be sharpened. What do you say to that? For me personally, I think it's ridiculous as a litigator. What do you say to that dichotomy between, if you're litigation, focus on public speaking, focus on being a great writer. If you're transactional, you could kind of coast. I mean, what do you say?
That is an absolute myth. Like you, Ted, I came to law school with a finance background. I had not practiced, but I studied finance. I got an MBA before I finally decided to go to law school. And so because I was, and still am, a shy introvert, that's how I consider myself. And because I had a business background, I came to law school fully expecting that I should do transactional work. Mm-hmm. I was not comfortable with public speaking. I was never the gunner, to raise my hand in class. That was not me at all. But ultimately, when I took what was back then the LCOM equivalent, it was called tutorial. I really enjoyed the process of legal research, analysis, and writing. And even though I was mortified when I had to deliver my first oral argument in class, and it was quite the out-of-body experience. But once it was over, I thought, wow, that was really stimulating. I mean, I loved it, right? Just that adrenaline and that sense of confidence that you get from having delivered an oral argument. My first summer, I interned at the third DCA. And I would go down for oral argument every opportunity I had. And I really became very enamored with that process. So when the time came to go through OCI and look for second summer jobs, I looked for a full service civil firm. And I ultimately decided to join Stearns Weaver for that summer. Fortunately, they allowed me to really split the summer between transactional work and litigation work. Wow. And at the end of the summer, when they gave me an offer, they were generous enough to let me choose between the corporate group and the litigation group. And at that point, I chose litigation with some trepidation, candidly, but I chose litigation. And I thought that at a firm that size, I would probably never open my mouth in court, until I was a fourth or fifth year. But much to my surprise, as soon as I was licensed, they started sending me into state court. And granted, in retrospect, I realized these were relatively minor hearings, not a lot at stake. But at the time, it seemed like, a fairly massive responsibility to me. And in that first year, I developed a lot of experience going into state court, preparing for those hearings, arguing and representing my clients at those hearings. And I was able to cultivate my skills that way. Ultimately, after about a year and a half, I decided to migrate into the employment group where our practice was primarily in federal court. Mm-hmm. And so many of those, really dispositive motions were being resolved on the papers. So I wasn't going to court as often, But when I did go to court, the stakes were higher because I was generally going into court for dispositive hearings. And then along came the trials and the appeals. And so, based on my own trajectory, which was not linear, I tell my students, you have to keep an open mind. And even if you do end up going into transactional work, that doesn't mean that your communication skills don't matter. The only difference is that you are executing those skills in the boardroom rather than the courtroom.
Wow.
But as a lawyer, no matter what you specialize in, you are going to be communicating every hour of every day in writing and orally. And so you have to burnish those skills. And they're completely transferable. Again, whether you are executing those skills in the litigation context or the transactional context, that is not important to me. What matters is that you are communicating and advocating on behalf of your client to get the best possible result.
And with that, I'm going to say myth debunked because a lot of people, and I heard it, and I have mentees now, Professor Torres. Not only do I do the mock interviews, but I also am a bar coach and a coach to incoming students, 2Ls, 3Ls. And all of them, they're like, well, Ted, I think I'm going to do transactional work. And do you know how many of them end up flipping? They're like, I kind of like litigations. I did a lit skill course, or I did a litigation class, and I kind of like it. And you never want to shoot yourself in the foot. So, Adon, I got to ask you, right? You're continuing school. Which route are you going?
Yeah, I had a
Transactional, litigation? Where are you at? What do you think?
I had a similar experience. I completely went into law school thinking just real estate contracts, real estate transactions. Like I did not ever see myself going into a courtroom or yeah, anything even close to it. I'm definitely open at the moment. My summer associate internship this summer is going to be fully litigation. I'm very excited about it because well, I realize I love to write, and that's one of the things that I really love, and that's part of the what like litigation does. A part at least half, if not more, is writing. But also, I took the LCOM 2 class. We had the oral argument. I think at first I was very hesitant. I didn't know what to expect from it. I was excited that I was gonna dress up. We ended up doing our final on Zoom, but I still, I had the suit. I had never worn a suit before. And the first time that we did it, we did a practice for the oral argument. And I remember, I played in a baseball stadium with thousands of people watching us before, but I didn't feel as nervous as I did that first time, doing our mock oral argument. But by the time that we did our final oral argument, it was like an adrenaline rush, and I really enjoyed it. And, as somebody that I had no aspiration of doing anything remotely close to litigation, I think that, when you come to law school, you come in with an open mind. And even, I mean, I'm going into my second year and I'm still like, okay, like I really like aspects of transactional. I really like aspects of litigation. Like, let's see where it takes me. But yeah, I think keeping an open mind is very important in that sense.
So, Adon, I mean, I've seen your resume. I know your GPA. You're top 5% in the class here. Would you consider yourself a gunner? Can you tell us what a gunner is, and are you a gunner? Because we hear all these scary stories how competitive law school used to be. And Professor Torres, I want you to chime in because it's a different time. There's a progression, just like we've seen different iterations of LCOM throughout the years, different names. It changes over time. So I want to understand, Adon, your perspective as top 5% of your class, and whether or not you're this gunner, and define it. And Professor Torres, I want you to chime in. Like, how has the education changed over time? Has it been because we saw Paper Chase, the movie Paper Chase. People are ripping out, important pages and books. This is like before computers. You had to go to the library, you had to find a treatise, you had to like look it up, and then you think you have it, and then boom, the page is ripped out because your classmates don't want you to do well in the exam. It was crazy time. So, Adon, are you a gunner? What is a gunner? And how did you get to be top 5% of your
Oh my
class?
gosh. I guess like a gunner is the person that always ready, they're gunning their hand up in the air. Any chance they get, they always have the answer. Uh, I wouldn't.
What's the relevance of that? Like, why do they want their hands up? Or like,
I mean, some of it depends on participation grades. I know the classes that have participation grades, you tend to get a little bit more of the gunner people coming out. But I mean, for other classes, I think it's just more for validation or I don't know. I wouldn't consider myself a gunner. And when I was an undergrad, I never participated in class, like never. When I got to law school, I'm a little more grown. I want to take it more serious, and I think it keeps you engaged. I wouldn't call myself a gunner, but if I made sure I got my words in at least once a class, just to keep myself engaged. They're long classes, they're an hour and a half. So if not, then you're scrolling your phone, or well, you're not on your phone, but people are scrolling their computers in class. So if you really want to stay engaged, I think participation is good. I wouldn't say I was a gunner per se. I don't know what do you think, Professor Torres?
I love the question. Having had the benefit of teaching Adon, I would not consider him a gunner, but I will say that from the front of the class, I always appreciated the fact that I could count on Adon to be well prepared for class. And anytime he raised his hand, whether it was to ask or answer a question, I could consistently rely on Adon saying things that were productive, that were really contributing in a meaningful way to the class discussion. And for me, that is huge because, I tell my students class participation and professionalism is a component of my grade, but it's not just because I want to grade you on something. It's because I don't want to spend an hour and 50 minutes hearing myself drone on. That's not the point. I want my students to engage, and I want them to learn from each other as much as they learn from me. So I always appreciated Adon's contributions to class. And Ted, you mentioned paper chase. So I would be remiss if I didn't say that rumor has it, I can't verify the accuracy, that the professor in the paper chase is based, at least in part, on a Miami law legend, Professor Hausler, who used to teach contracts.
Wow. It's always the contracts professor. It's always, you know, offer, acceptance, consideration. It's always contracts. So
All roads lead to contracts.
all roads, even if it's on a napkin, Lucy V. Zimmer, look that up. I'll never forget that case. On a napkin, a text message, on your hand, verbally, contracts are formed every day. And that's going to be for a later podcast. But how was it for you, Professor Torres? Because was it as cutthroat, back then when, resources were a little bit more finite and, there wasn't the breadth of computer and ease of information? Like, how was it for you, your law school experience?
I will say that there have been certain changes, and I think the change was already underway when I was in law school. I started in 90, graduated in 93. It was already becoming more accessible, but there was still this notion that a good law professor was supposed to be intimidating,
Wow.
was supposed to make you feel less than, supposed to make you feel unworthy as a student. And that's definitely not the ethos today. The ethos today is absolutely about making students feel welcomed, making them feel comfortable contributing in class. And I think that is all for the better. In terms of resources, Westlaw and Lexis were just emerging as tools when I was in law school. So my first year in the fall semester, we were taught how to research exclusively using the books. We were not allowed to use Westlaw or Lexis. We were not even given passwords for Westlaw and Lexis. And yes, Ted, you mentioned this idea where students would rip pages out of books. That would happen.
Wow.
So our tutorial professor would give us these hunts that we were supposed to go on, these research hunts in the library, and you would dutifully follow the steps and you would get to the conclusion and the page had been ripped out or the case was missing. And it's crazy to talk about stories like that. So of course, now that we all use legal research tools, computerized legal research tools, that is no longer a problem. But more importantly and more beneficially, I think the ethos among our student body today is completely different. I could be wrong, but as I talk to my students, as I witness and observe my students engaging with each other, I think the student body is really very supportive. And I love that. I think that's a fantastic change to legal education and to the profession generally. The profession is paying a lot more attention to well-being, and I think supporting each other is a huge part of that. And I'm grateful to say that I really see that among the student body at Miami Law. And I hope that was your experience, Adon, and your experience, Ted. I know you were in law school to some extent during the pandemic, so that was a really unfortunate, traumatic time where we were all pivoting, and I'm sure that had an impact on your experience. But I think by and large, most law schools are trying to provide a much more supportive, collaborative student experience. And I think that is all to the better.
Yeah, I'll second that. I thought my time at UM, I mean, it was very collegial. I mean, I was friends with a lot of my classmates, like actual friends. Like we would hang out and we would study together. We'd help each other out. I mean, obviously the curve makes it a little bit competitive. We could talk about that another episode, Ted. But I thought, all the professors. I mean, some were intimidating at first, but at the end, by the end of the semester, they were just very friendly and very willing to help. So I think that might be a little bit of a myth as well. Like the people, like the conflict of law school, between students. I think most of what I've heard and what I've experienced is people helping each other and just trying to make it out alive. Law school is not like undergrad. It definitely takes a lot more time and effort, and so it's just like the more that you could collaborate with others, it just helps to get through it and get out into the workforce.
Yeah, and that's what's important. And to really share a little bit about my experience, Professor Torres, I felt so welcomed and felt a part of a team at the University of Miami. I didn't feel like there was anyone gunning for me or this cutthroat mentality or even this mentality of things are finite. It was like, all right, how can we help each other? These are large law firms. They need hundreds of new lawyers. Like I can't think, well, they're only going to take one from University of Miami. It was more collegial and very helpful. And it makes me think, as a former partner uh, at Stearns Weaver, what sort of law students would you hire, Professor Torres?
Sure. And let me just begin by saying that it's extremely gratifying to hear that both of you had such a positive experience at Miami Law. That's obviously what we're working towards. So it's very satisfying to hear that both of you had a positive experience. Going specifically to your question, Ted, once I joined the employment group, the bulk of our practice was in federal court. And as both of you know, in federal court, less than 2% of cases actually get to trial. Mm-hmm. And even at the pretrial level, very few matters are scheduled for oral argument. So my students are often shocked to learn that I litigated entire cases from start to finish, sometimes without ever seeing the judge, because all of the disputes were being resolved on the papers. So because good writing was pivotal to our success and our clients' success, we absolutely focused on students and lawyers who were good writers, right? We could not discount the importance of good writing. So obviously, a GPA only tells you so much about a person's skills and qualifications. We always looked to see what else the student had done to cultivate good writing skills, whether that was moot court, law review, how much writing had they done in other jobs that they had during law school, perhaps postgraduate clerkships, of course, provide a fantastic avenue to continue to burnish those legal research and writing skills. We would review writing samples, as many as the applicant would give us. That was essential. And then, of course, beyond the writing skills, just the oral communication skills. How comfortable are you just sitting across a desk or a table from someone, looking them in the eye and having a meaningful conversation? Soft skills, right? Emotional intelligence, The chair of our group, the employment group, would always say to us when we were, developing as associates, our clients can hire the best attorneys across the country. Anyone in those firms can generate good results. Not every lawyer is also capable of remembering that the law is a service profession. So
Wow.
we serve as business partners to our clients. We serve as trusted advisors to our clients. When they ask us a question, we don't treat it like a law school exam that's getting to maybe, right? And it's just giving them three options and forcing them to choose. We are giving them our best advice on the best course of action, right? What are the benefits and potential pitfalls of that course of action? We are constantly communicating with them. Our clients never have to guess what we're doing on their behalf. Every month, they don't just get a bill from us for services rendered. They get an update. What are we doing on your behalf? How are we advancing the ball to reach the best result in your favor? So it was that component or that overall mix of good work, good results, but always wrapped in this notion of service and communication that really set us apart, I think, from other law firms.
Yeah, and Professor Torres, would you say that's the same attitude major law firms are looking at now when they're looking at hiring, a summer clerk, or hiring a full-time associate, maybe taking on a lateral individual, looking at their writing, looking at their soft skills, looking at who they are as a person, looking at how they communicate, looking at some of their successes, their overall background, because the further you get removed from school, your GPA doesn't matter. I've never sat in an interview like, well, Ted, we'd love you, but your GPA, man. I'm like, well, I've been practicing 6 years now. I actually have cases I've won. My clients are happy. I have substantial writing. So, would you say currently it's the same criteria being used today to hire, like students, lawyers, laterals, and the like?
I believe so. At any law firm, the greatest asset is the roster of attorneys they hire. And for every attorney, our greatest asset is our reputation. They say that your reputation precedes you, and that is absolutely true in the practice of law. But reputations are really fragile. It can take years to develop a good reputation, but it takes just an instant to tarnish that reputation. So I think all law firms, all legal employers are looking for someone who has a reputation for excellence. And not just in terms of excellent work product and excellent results, but excellent character, judgment, honor, integrity. I did a lot of recruiting at Stearns Weaver, and the question I would often get is this person a good fit? Is this person one of us? And by that, what they're asking is this someone of good character that we can trust to represent our clients with the highest level of professionalism? Somebody who will never engage in unethical or immoral or illegal conduct that will embarrass us, embarrass our clients.
It's good to hear. And to our listeners, that are either practicing, you've gotten some real nuggets, not only from a former partner at Stearns and Weaver, but also, 15 years in the game doing this as front line of defense, the first one of the few people you meet as you start law school that stated not only does she teach you, but she has an open door policy to talk about just life, where you want to go, what's going on. So like I've seen that change and I applaud you for it because I'm thinking of other professors that have had this mentality of like, listen, we get it. Your first year, first semester is challenging. Let's talk. What else is on your plate? What's going on? We want to make you better. So it's definitely important. So if you've heard that, as a growing associate, you're hearing that as a 1L, 2L, 3L, or just law curious. You're hearing what's important not only now, but what was important back then and how they coincide together. And as we transition and we try to wrap this up, I gotta ask, in your LCOM class, is there a lot of note taking?
Yes, but surprisingly, not as much as I would like.
Why is that?
So I think it's essential for students to take notes. And there's a lot of research on note taking by hand being superior to note taking on a device, but I won't pass judgment on that. I let my students take notes using whatever method they think is best for them. But I find it surprising that sometimes in class we're talking about concepts that are really essential and are not necessarily set forth in the PowerPoint, and yet students aren't necessarily taking notes. And so that worries me a little bit. And I have seen, I must say, a correlation. I think the students that take notes more consistently in class tend to do better, at least in LCOM, because I think that they are capturing the material. We touched upon it earlier. It's a recursive process. When you're thinking, analyzing, writing, that's how you learn. That's how you think about the law. That's how you learn the law. That's how you refine your analysis. And that's how you ultimately perfect what you're trying to communicate. So I would encourage students generally across all of their classes to be really diligent about taking notes, because I think that helps them internalize and learn the information that's most important for that class.
Adon, we're all wondering how did you take notes in Professor Torres's class? Please and thank you.
Yeah, I mean, one of the things for that class, the PowerPoint slides were really good, like much better than my other classes, at least most of them. There's maybe one or two other classes that had good PowerPoint slides, but a lot of the notes were on the slides. And so to take notes, in LCOM, like you really had to listen. And so, the people that probably weren't taking notes, they weren't really listening. Because there is a lot of information that is not said on it's not written on the PowerPoint slides, that is just said orally. And there's some really good nuggets there. At least for me, I mean, I would listen. They would send us the PowerPoint slides, and you'd have them up in in half your computer, and I would have my notes on my other half. And yeah, it was just a lot of listening. I think just listening for those nuggets. But I mean, if you're not taking notes in law school, like it's not a good sign. But.
Yeah, and for me, having now, right, completed all 3 years, Adon, I can't think of one class that I didn't take notes in. Not one class. I can't think of one. Uh, so notes are quite important. And Professor Torres, I'm not sure if Adon told you how efficient he got at taking notes, because this podcast is sponsored by Law Bandit, which is an AI tool developed by Adon. So Adon, I'm going to let you plug it, shout it out, and how it made you much better note taker.
Yeah, you know what? Actually, this is probably not the right episode for it. Because again, we just had so much information in the LCOM class that I just didn't take as many notes as I would in other classes. I was more listening and trying to get those nuggets. As far as like the platform, the Law Bandit platform, it's more for note taking. It's not so much for like generation of written material. I mean, I would use it sometimes like we were doing like appellate style assignments in that class, and so the first couple of classes I didn't really understand what we were even doing, or what appellate court was, or how it worked. And so for that, I was using the app a bit to just ask it like what if Professor Torres said motion to dismiss, and I didn't even know what that was, then I would look that up through the app. um but LCOM is very, I mean, it teaches you from first principles on how to write, and so a lot of it was very manual, which I think is good, because if you don't know how to manually produce content as a legal writer, then you can't really rely on artificial intelligence to do it. It's just not going to come out pretty well. I don't know, Professor Torres, what you think about AI and how it's progressed in the law, and maybe pros and cons.
Yeah, I love the point that you made that if you don't understand the law, you can't really rely on AI because there's a lot of garbage in, garbage out. I do think that the proliferation of AI tools carries both benefits and pitfalls for lawyers and judges and, of course, law students. As a legal educator, I think it's my responsibility to make sure that I start to introduce my students to those tools with an emphasis on learning how to use those tools ethically, efficiently, and effectively. I think not a day goes by, I feel like, without reading an article about a lawyer who is sanctioned
Yep.
for filing a brief with hallucinated cases, law that is non-existent. Just this week, there were two really notable examples. Yesterday, Judge Leibowitz of the Southern District of Florida published an excellent order sanctioning a lawyer who repeatedly, even after being put on notice, repeatedly across 8 different cases, continued to rely on non-existent cases that were hallucinated by ChatGPT. Likewise, this week, a federal district judge in New Jersey had to pull one of his own opinions because it had a number of incorrect quotes. So it's incumbent on all of us, law students, lawyers, judges, to learn how to use these tools. The advent of AI will be paradigm shifting for the legal profession. I don't worry that AI will render lawyers obsolete. The practice of law is ultimately about your relationships, personal relationships with your clients, and your judgment. And AI is not going to replace that. But I do worry about lawyers who do not take the time to learn how to use these tools. These tools will bring productive efficiencies, but in order to benefit from those efficiencies, you have to know how to use these tools correctly without jeopardizing the quality of your work product and without disclosing confidential client information.
Wow. I mean, it's no
Mic,
shocker to
mic
anyone
drop.
listening. Yeah, it's no shocker to anyone listening that that was very well articulated, very well said. Professor Torres, I wouldn't be surprised if we ask you to join us again for another episode because there's just so much. You've done so much, and there's so many questions we didn't get to. We want to touch on involvement, moot court, oral advocacy, how that looks like, the interplay between, private practice and teaching. You said so many great things. I'm writing them down, from the boardroom, not the courtroom. And you said, the your journey started with understanding by beginning and learning the law, applying the law, and then giving back to the profession. And between you and I, that's my end goal. At some point, I want to be a teacher. So it really resonated with me to hear that, you know what? Professor Torres did it. She went through law school. She worked at one of the largest law firms for years. And she just had that realization, I want to give back. I want to teach. And I'm not going to teach, not to say any old class. I'm going to teach one of the most important classes, and that's just my opinion. One of the most important classes in law school, and I'm going to do that. And now I'm celebrating 15 years of just giving back to the profession. And you've probably touched countless souls, guided countless individuals, and it really resonated with me because I'm only 4.5 years into my practice, and I'm already thinking about teaching. So I want to say thank you, Adon. I'll let you close this out, but definitely please be on the lookout for an email from us because we definitely want you back on the pod so we could talk about the other things on your long resume that students, associates, and just law curious individuals can benefit from listening.
Professor Torres set the bar high on the Bar None podcast.
You sure
So,
you did. You did.
yeah, so thank you so much, Professor. And like Ted said, we really look forward to hopefully having you again. And we wish you we wish you a great semester and just continued success. And say hello to Rio for me.
Thank you so much, Adon. It has been just such a great pleasure to chat with both of you. I applaud you on developing this podcast. I think it's going to be a great asset for law students, lawyers, and as you say, the law curious. So I really appreciated our conversation, and I look forward to continuing it. And Rio will appreciate your good thoughts, Adon. So thanks.
Thank you so much. All right, Professor. We'll see
Bye
you.
for now, and we'll see
Take
you
care.
soon.